us on track. Good evening, everyone, and thank you so much for joining us here tonight, whether you're here to listen and learn or to be a part of the event. And a special thank you to the candidates who have so graciously agreed to give us their time this evening ahead of the May 18th primary elections. I'm really looking forward to this important conversation on what the judiciary can do about issues related to criminal justice. My name is Dee Hubey, and I'm a student at Duquesne University, president of the Sociology Club, member of the Elsinore Benu Think Tank for Restorative Justice, and supporter of the House of Life, who are all sponsoring this event with us tonight. I'll be orally moderating this event alongside my co-organizer, Lauren Courtwright from Slippery Rock University, who will be visually moderating this event via the chat function. This panel on the issue of justice was inspired by Charlie Lewis. After being unfairly sentenced to 30 to 71 years for a first major offense, Charlie utilized every legal avenue at his disposal until getting his case overturned by the Third Circuit Court via a handwritten motion he had submitted 17 years prior. As a result, Charlie was finally released in 2004 after serving 18 years. After proving a constitutional violation, his case and legal battle set national precedent for countless others across the country and is still in the federal law books today. A few weeks ago at a think tank meeting, while talking about the upcoming primary, dedicated think tank member Charlie Lewis spoke up. Why don't you organize a panel and let us, those with lived experiences inside the justice system, help ask the tough questions? With 39 candidates running for 9 open seats, with the primary just around the corner on May 18th, and with no good answer to why don't we did. With the importance of voting and voting rights being at the forefront of our democracy, I just wanted to provide a quick bit of information and resources for voting before moving into the discussion. For those who already registered to vote, I encourage you to check your voter registration status with the PA Voter Services. The in-person polls will be open from 7 a.m. to 8 p.m. and as long as you are in line before 8 p.m., you are still legally allowed to vote. Tomorrow, May 11th, is the last day to apply for a mail-in or civilian absentee ballot, but please keep in mind that all mail-in ballots must be received by May 18th at 8 p.m. in order to be counted in the election. If you're not already registered, you'll be unable to vote in this primary, but you can still register for future elections. For more information on checking your voter registration status, locating your polling place, registering to vote, or applying for a mail-in or absentee ballot, please use the corresponding links posted in the chat by Lauren. Lastly, before we begin, please join us again tomorrow night at 7 p.m. for session 2, where 10 other candidates will share their thoughts on what the judiciary can do about criminal justice reform. Turning now to session 1 on the issue of justice, I will briefly explain the course of tonight's event. With 11 candidates joining us tonight, it was important for us to implement time constraints on candidate answers so that we have a chance to hear from each of the candidates. Each candidate will be given 3 minutes and 30 seconds to answer each question. Our timekeeper for this evening will be Dr. Cindy Lacombe from Slippery Rock University's Gender Studies program. In order to be considerate of everyone's time, candidate microphones will be promptly muted at 3.5 minutes. As a reminder, please keep yourself muted unless you are a candidate whose turn it is to speak. Candidates will answer questions in alphabetical order by last name. Joining us here tonight, we have Bruce Beamer, Jason J. Cervone, Nicola Henry Taylor, Brian Samuel Malkin, Lisa Middleman, Zeke Redeker, Matt Rogers, Giuseppe Rosselli, Jimmy Sheets, Patrick A. Sweeney, and Andy Zeffi. Lauren will be putting all questions asked into the chat so the candidates and audience may refer back to it at any point. Please submit any questions you have directly to Lauren in the chat so that it does not distract the candidate who may be speaking. If we have time at the end, we will turn to the submitted audience questions that Lauren will keep on file. And without further ado, it's now my honor to turn to the candidates and begin our panel on the issue of justice. Question 1. According to experts, activists, and advocates in the field of criminal justice reform and restorative justice, cash bail, probation, and parole are considered to be 2 of the most pressing issues. Cash bail fills the jail with poor people prior to trial, regardless of guilt or innocence, which severely damages their already precarious lives and the lives of their families. This can include things such as a loss of job, loss of housing, etc., that will often follow after only just a few days of pretrial confinement. The issue of probation has much to do with the large prison population in Pennsylvania. The length of probationary sentences, especially when they are extended time after time, can cause individuals to be in violation over arbitrary matters such as missing or making a late payment on fees, fines, or restitutions. Given these facts, what is your position on cash bail and probation, and what can a judiciary in the common pleas court do about it? In other words, do you feel that cash bail and probation are effective? Why or why not, and what will you do about it? We will first turn to Bruce Beamer.
Hi, thank you so much for having us here tonight and for doing this forum. It's a great question. And I would like to say that this is actually something that I have had a lot of familiarity with over the last 15 months or so, because when I was appointed to the Common Pleas bench, I went directly to the criminal division. So I am on a regular basis addressing issues surrounding pretrial incarceration as it relates to cash bail and as it relates to sentencing, the length of probation and parole sentences, and what to do when someone may not be in compliance with probation or parole. And I'll start with cash bail, which is the issue that really surrounds what to do with individuals. How do you make sure that they appear for trial? And I have long held the belief that pretrial cash bail, particularly as it relates to nonviolent offenses, is a huge mistake because it disproportionately punishes individuals that may not have financial needs. And so on a regular basis in my courtroom, when I come into contact with an individual that may be held pre-trial with a cash bail situation, we look at factors outside of monetary as to how we can assure their appearance at trial. We use non-monetary conditions of bail on a regular basis. It works, and it's unnecessary to use cash bail in the vast majority of situations. As it relates to certain issues surrounding somebody who may have a violence in their past or may be a danger to a specific person or the community, we have to address those issues in terms of whether or not someone should be entitled to bail, but that should be a very strict set of conditions and proof that we require the prosecutors to get to. So as it relates to probation and parole, we're overusing the length of probation that we give to individuals. And that's really has a very detrimental effect on individuals. I happen to have the sex offender court where we have individuals that are convicted of sex offenses against minors. There may be reasons to have longer periods of probation or parole to supervise and monitor those individuals. The vast majority of individuals that come into the criminal justice system that are nonviolent offenders typically need a short period of supervision to look at and address maybe substance abuse issues or mental health treatment. But once we get past a short period of probation or parole, holding them for long periods often is just asking for and inviting real problems for them. So I really try to fashion and have been fashioning much shorter periods of probation than have typically been seen in Allegheny County or throughout the Commonwealth of Pennsylvania, because I think that in those situations, it just doesn't work and it hurts people unnecessarily. So we need to look at those reasons as far as shortening probation and parole, except for some really extreme cases. Thanks.
Thank you.
Thank you so much for your comments and your insights there, and thank you for being prompt. I will now turn to Jason Servone. I will now turn to Nicola Henry Taylor, and we will circle back if they're able to join us later. Thank you.
Thank you. Good afternoon. I think we can all agree that pretrial detention and monetary bond disrupts families, communities, and criminalizes poverty and disparately impacts people of color. And I think that's something most of us can agree on. We could solve this problem not only through a greater legislation and having the judges be a part of work groups that are statewide on rules and being a part of discussions on best practices throughout the state, such as what the Pennsylvania State Interbranch Commission on Racial, Gender, and Ethnic Fairness has a work group that we have, I believe Judge Clark is a part of. They can be a part of those best practices, but also on a local level, we do have a board of judges. They can be working with the magistrates to talk about how monetary bond should be rarely used, and it should be only focused on when we're avoiding people not showing up for court, and not to be used in every single instance, and to be able to ensure public safety. And there are other safety precautions that could be put into play. The other thing is working with our other stakeholders, such as the Public Defender's Office, to make sure that we have representation at important decision points, such as a preliminary arraignment, so that we're discussing and people aren't just sitting in the jail waiting when they could have been released because somebody paid attention to them. With respect to probation, some solutions that could be put into place is making sure that new charges are scheduled at the same time as gag-non hearings or probation violation hearings, and things are being handled more succinctly. And all of these things can be done when people put their heads together and discuss things intentionally. When I did mental health court as an assistant DA, those changes were made because judges, the court administration, and others made those changes. And so we can, as a county, make changes and look at what other counties are doing well and improve the fact that so many, I believe pre-COVID, there were about 50% of the population was there on pretrial detention, and now that's gone down due to COVID release. So probation is not working in Pennsylvania. We're seeing that people are, it looks like a restorative sanction and it is under the sentencing guidelines, but when they violate, we're seeing that people's lives are being disruptive and they're spending more time in jail.
Thank you, Nicola. I really appreciate you sharing that with us. Next, we have Brian Samuel Malkin.
So here's the problem with cash bail. Black nonviolent offenders have for years been disparately impacted by overzealous sentencing, fines, and technical probation violations, more in Pennsylvania and Allegheny County than other places. Folks who are poor, homeless, mentally ill, or have drug or alcohol addictions are not criminals, and putting them in jail is not humane or just. This practice has decimated families and communities in our county. It's disproportionately impacted on the Black communities and families and needs to stop. It's obvious that cash bail is unfair to folks that have no resources. It creates a debtor's prison. We keep accused folks in jail while they lose their jobs, homes, and loved ones, spending over $100 per day to ensure that they return for a court date, where the possible penalty does not include jail time. That number rises to $50,000 to $60,000 a day if you put somebody in prison. And the thing is, it's not protecting communities from violent offenders, and it's having a disproportionate impact on Black and minority offenders who are being over-sentenced, over-fined, and over-incarcerated, and being put into prison for technical probation violations more so than white offenders. Eliminating cash bail for nonviolent offenders is crucial. Cash bail decisions have disproportionately unfairly impacted the Black and other colored offenders. So to ensure these offenders appear for their court date, it's not even-handed and it's not fair. There's no income review before bail is imposed, and that makes it arbitrary and unfair for folks who have limited or no income or assets. Often a child's first offense negatively impacts on their parents or loved ones who are forced to put together much needed bail. They may have to use their homes or other life savings to leverage them for bail. We need our Court of Common Pleas judges to review bail decisions automatically when it comes before them, and to take a look at household and individual income that's been made by a district judge so we can get these folks out of jail. We know that 90% of the defendants released of their own recognizance return for their court date, so there's no need to keep these folks in jail, no reason at all. Now, as for technical probation violations, that should not be a reason to put an offender back into prison for longer periods and to put more fines and sentencing. Much like cash bail, the technical probation violations are unfair and disparately impact on Black and other colored offenders and needs to end. An offender on probation for a nonviolent offense may have had a bad day, late for a meeting with a probation officer, or their car breaks down, or they test positive for drug or alcohol violations. But that doesn't endanger the community. It takes far less money to get the offender the proper help and to get them the help that they need through social services. Maybe a better approach would be a halfway house where they can get the treatment they need, medication they require, and the education and support services they need to get back on their feet. The programs are out there. I spoke to a lady just the other day who says, in her view, the courts in the county are not reaching out to these programs and services very much, if at all. It's something the Court of Common Pleas judge can and must do. Thank you.
Thank you so much for your insights. Everybody has great things to say here tonight. Next, we will have Lisa Middleman.
Hi, everyone. Thank you for this question. You know, cash bail has been something that a lot of people have been talking about. And honestly, common pleas court judges have very little to do with cash bail. They may review a bail decision, but the initial bail decision is made by a magistrate. And the part of the problem with cash bail is that and I can kind of explain the process. Anyone who is arrested goes before a magistrate, and the magistrate arraigns them and tells them what the charges are, and they set a bail. So before a bail is set, an individual is interviewed and they fill out paperwork. And one of the forms that they fill out is basically a bail assessment form that assesses the risk that the person is a danger to the community and or will fail to appear. And those answers to those questions are fed into an algorithm that spits out an answer about whether the person is a risk. Unfortunately, a lot of the data that is used to put those forms together and to put the algorithms together is racially unfair. Because if you live in a community where you are over policed, you're going to have more arrests than an individual who lives in a community that is not over policed. But the reason for having these forms was because magistrates were making random and arbitrary decisions about bail. So what ultimately, cash bail should be totally eliminated. That isn't the province, though, of a common pleas court judge to make that decision. Someone should not be able to get out of jail if they're a danger to the community simply by paying cash bail. And the converse is that somebody who is not a danger to the community should not be remaining in jail because they cannot pay a cash bail. The issue of probation and parole, I think, is a much more pressing and interesting issue because lengthy periods of probation were traditionally given to people so that they could pay court costs. You know, every time an individual is convicted of a crime, there are court costs assessed on them. And sometimes and frequently they're in the thousands of dollars. So they would have lengthy probationary terms so that they could pay off the court costs. In addition, so we don't need these lengthy periods of probation. I'm a data-driven person, and studies have shown that if an individual is going to recidivate, it's going to happen within the first year of probation. So like Judge Beamer said, certain sex offense cases may require lengthier periods of probation, but the majority of cases do not. In addition, probation violations are a problem. When an individual is accused of violating their probation, a warrant is issued for them, and they are frequently lodged in the Allegheny County Jail while they wait to go before a judge who will assess the severity of their violation. 80% of those people are technical violations. That means they haven't committed another crime. And half of those technical violations are substance abuse problems. So we need to really evaluate, whether we need to actually automatically detain those people, and the answer is no. And B, what we should do about people with technical violations as a result of substance abuse. And the answer to that question is treatment, not incarceration.
Thank you very much, Lisa, for explaining that to us. Next, we will turn to Zeke Redeker.
Thank you. And I really appreciate you guys having me. And I want to talk briefly about cash bail, and then I want to tell you a story about probation, a case that I worked on. So with cash bail, the question is whether or not an individual can afford to pay. Two people can be charged with the exact same crime. One can pay, he or she goes home to his family. The other person cannot pay, they go and sit in Allegheny County Jail. And if you go and sit in Allegheny County Jail while you await your proceedings, the likelihood that you will lose your job, your home, the likelihood that your family will be affected because if you have custody of your children or you take care of a dependent family member, all of these things are at risk if you have to sit in Allegheny County Jail while you await your proceeding. I don't know of any job in the country where you can take multiple months off and just return to it whenever you're done sitting in jail. So, I echo the rest of the good candidates on this call in saying that judges need to use their discretion, which is the most powerful thing that a Court of Common Pleas judge has, in order to minimize the use of cash bail because it disproportionately affects low-income communities and communities of color. The second thing I wanted to talk to you about was probation. I actually got a case that was referred to us at Reed Smith, the firm where I work, a couple of years ago that involved a man who had been charged with assault. And this case came to us through the Reform Alliance, which was started by two rappers, Jay-Z and Meek Mill, to advocate for nationwide criminal justice reform. And this man who had been charged with assault, he had no previous criminal record, and he disputed the circumstances. So unlike a lot of criminal defendants, he decided to take the case to trial. Most criminal defendants decide to plead guilty, like upwards of 90 to 95% in our system. So right before the jury was about to deliberate, he reached a deal with the prosecution where if he were to plead guilty to assault, the prosecutor would agree for him to get a probationary sentence. So what do you think he did? He took the deal, went home to his family. 2 years later, the prosecutor hauled him back into court, alleging that he was violating the terms of his probation. The only problem was that his probation officer didn't bother to show up to the hearing. So there was no admissible evidence that he was violating his probation. That didn't stop the judge on the Court of Common Pleas from not only revoking his probation, but giving him 5 to 10 years in state prison. Okay? So he sat in prison for 3 years before we got this case. And we came on and we filed all of our habeas motions, had a series of hearings in front of a new judge. And when it was the prosecution's turn to respond, they shrugged their shoulders and said, you know what? We're not even going to file a response. You guys are right. And we had this incredible moment where we knew we had won our case, but we knew we would never get those 3 years of his life back. And I can't tell you how many people are affected by this, these kinds of issues who are caught up in our system. We need these kinds of criminal justice reforms badly on the Court of Common Pleas. And I'm sincerely hopeful we can bring good change to the bench this spring.
Thank you very much for your comments here tonight. Next, we'll turn to Matt Rogers.
Evening, everyone, and thanks for having me and for putting this on. I guess first, with respect to the cash bail question, I think most of us are sort of in, if not lockstep, with similar minds in terms of the effective use of cash bail. And largely, it's my position that anything and any use of cash bail for nonviolent offenders, drug offenders, those are like those that are like relatively minor crimes. It's just essentially entirely unnecessary. All it does, which some other attorneys have mentioned already, it sort of it disproportionately punishes those of a minority status or without the means to essentially get themselves out of jail. And they sit in Allegheny County Jail for 30, 60, 90 days or longer, just awaiting trial. The one thing that really, the practical thing that I would want to implement in terms of bail is, and somebody else, maybe Attorney Middleman mentioned earlier, that the common pleas judges are the ones that they don't set bail, but they are able to review bail. And I don't think there's any reason to not have regular bond review hearings that are just scheduled sort of out of course. I mean, each judge has the ability to set their own schedule and review their own cases sort of at their convenience. And to the extent that, I would be elected, that's something that I would want to implement, should I be assigned to the criminal division, is that you can have these weekly or whatever bond review hearings with the new cases that have sort of come before you, and make the determination very quickly as to, okay, wait, is the bond that was set by the magistrate appropriate in this case? And if it wasn't, what do I need to do to fix it? With respect to probation, I mean, it's sort of twofold. One, it's overused and it's too long. Allegheny County has some of the longest average probation terms in the state of Pennsylvania. I don't know why that is or why it's necessary, but it's not. These long probationary periods only sort of, they enhance recidivism, and things like the technical violations, people that don't show up, people that, sometimes things like transportation are an issue. For these, the type of people that are on these probationary sentences, sometimes they have very practical reasons for why there may be some sort of minor technical violation, and for a judge to revoke and resentence to some long jail term just because of a technical violation is not really within the spirit of reformation of people that have been placed within the system, and that certainly needs to change.
Thank you very much for your comments as well. Next, we will turn to Giuseppe Rosselli.
Thank you. I really appreciate the opportunity. So there's not much more I can add to the cash bail conversation. It's been pretty thoroughly discussed, and if you want my position on it, I can tell you that attaching one's freedom to their financial ability cannot be part of a system that calls itself just. We have cash bail for two specific reasons: getting people to court, and as Mr. Malkin said, 90% of people who are given an ROR bail show up for court. So I'm far more focused on whether or not they're a danger to the community, and no amount of money can be posted to gain one's freedom if they're a danger to the community. They either are or they are not. As it relates to probation periods, currently the state of Pennsylvania, on average, imposes the longest period of supervision, either parole or probation, than any other state in the country. So that's not Mississippi, Alabama, Texas, Florida, it's Pennsylvania. And Allegheny County, on average, has the longest period of supervision in the state. The national average is 22 months of probation and supervision. In Allegheny County, we're almost double at 42 months. As others have said, it creates a disparity, which creates a greater likelihood of violation for minor infractions, like a positive marijuana screen or failure to pay court supervision fees. In order to address that, our focus should be to reduce the length of probation sentences to be at a minimum more in line with what the national average is, eliminate the use of consecutive probation periods, use graduated sanctions that are fair and swift for minor violations, and assess court fees on a graduating scale based on the individual's ability to pay.
Thank you very much.
You're welcome.
Next, we will move to Jimmy Sheets. I appreciate everybody's comments here tonight.
Jimmy, you're muted.
It happens to the best of us.
Good evening, Dee. I want to thank you and your organization for this forum and for inviting me to it. I apologize for my sort of haggard appearance compared to everybody else. I was putting together and putting out signs right before this. Okay, so Clarence Darrow said that laws should be like clothes. They should be fit to the people they serve. Attorney Middleman touched upon this, and that is that cash bail is not the purview of a court of common pleas judge. Somebody else suggested that, judges regularly review bail. We do that in Allegheny County. If a magistrate holds someone without bond, it is automatically reviewed by a judge on the Court of Common Plea. I argued bond this morning for a client who had his bond revoked last week because he picked up new federal charges. And I was able, with the federal public defenders, to convince the state judge here in Allegheny County to release him to an inpatient drug and alcohol treatment program and then to house arrest. I do that pretty much once a week, several times a month, because we do that in Allegheny County. If bonds are excessive, the public defender's office is at motions court every day. Private defense attorneys file motions on behalf of their clients every day to get them out. So bail abatement, the reason I mentioned Darrow and laws fitting the people they serve, eliminating cash bail in the Commonwealth of Pennsylvania would be a legislative act, not one by a single judge on the Court of Common Plea. If elected to serve on the Court of Common Plea, I would consider the same factors we do now: a person's dangerousness to the community, their prior criminal record, and whether or not they have a propensity to show up for court. Then and only then, if it were necessary, would I set a cash bail or fail to modify one. Okay. As far as probation, I think what distinguishes me from the other 38 candidates is I went to the Allegheny County Jail for a technical probation violation. While I was on probation for not one, but 2 DUIs, I continued drinking. Condition of my probation was that I abstained from the use of alcohol. I was jailed for 9 days. From there, I went to inpatient treatment. I was jailed May 17th, 2017 for technically violating my probation, for putting myself and the community at risk by continuing to consume alcohol because I was a repeat DUI offender. I haven't had a drink since May 18th, 2017. Judge David Cashman saved my life and protected the community by incarcerating me. So that's what distinguishes me from everybody else that wants to talk about the length of period of probation. When we put someone on probation, the conditions are you pay your fines and costs and you abide the law of the Commonwealth of Pennsylvania. As a judge, I would be fair, impartial, and consider what is affecting someone's life and their decisions, and as often as possible, use diversionary tactics in sentencing. Thank you for your time.
Thank you for sharing that with us, Jimmy. Next, I will move to Patrick A. Sweeney.
Thank you very much. I hope you can hear me. One of the bad things about being late in the alphabet is that you basically have to go behind everybody else that's pretty much giving the same answer that I would have given if I had gone first. So I'm not going to belabor too much about this issue. I'm a public defender. I've been with the public defender's office for 23 years. The people that can't afford bail are generally my clients and my colleagues' clients. I would disagree with my former colleague, Mr. Sheets, slightly. I think we can perhaps change the practice of what magistrates do through some encouragement by the president judge who supervises these magistrates to discourage the use of cash bail even more than what it's being used right now. I remember one of my favorite stories when I was in front of Judge Dower. He took a recess from the bench to accept a phone call. He didn't realize his microphone was on while he was berating one of the magistrates from out in the suburbs about, something that she had done wrong. And of course, everybody in the courtroom got to hear it. And I knew who the magistrate was, and I believed that she deserved it fully. So I got a big chuckle out of that. But the president judge can discourage misbehavior by the minor judiciary in this manner. I think just as far as society is concerned, I think you got to think of it this way. Why would anyone who is presumed to be innocent, and everybody who's just charged with a crime is presumed to be innocent, why would anyone be incarcerated before they've been deemed to be guilty? The answer should be almost no one, unless, because you've got probable cause to arrest them and it's a violent crime, then maybe we should consider locking them up. If you set a bond, even if it's $1 million, you're basically telling the world, I'm all right with this guy getting out of jail as long as he has the money, which means you're all right with a rich person getting out of jail and not a poor person. And that, of course, is absurd and should be done away with. With respect to probation, again, it's a lot of my clients that get tied up in this because they can't afford to pay their fines and their costs. And the fines and costs very often interfere with them being able to pay restitution, which of course is the main priority if you have an offense that you harmed someone. If you've ever gotten a speeding ticket and you see how the $25 fine suddenly turned into a $130 bill because there's all these little categories on there and funds that extract money. Well, it's the same thing with court costs. You get convicted of a crime, even a minor offense, you get a big long list of funds you got to pay for. Judges can waive those court costs, but supervision fees for the longest time they could not waive. And those supervision fees add up. And a lot of times people have trouble paying them. And that's the reason for a lot of these technical violations is the failure to pay supervision fees as well as court costs. And judges have the ability to use their sense of justice to waive costs when necessary. So I think individually and collectively, the Court of Common Pleas should do everything they can to make sure that justice is being applied, not simply, it should be applied fairly in taking into account people's financial condition. So, thank you.
Thank you very much for your comments. And for our last person for this question, we'll have Andy Zeffi, but we'll be sure to go in reverse alphabetical order for the second question. Andy Zeffi.
Little curveball there on the second round. Appreciate it. I commiserate with Mr. Sweeney's alphabetical troubles, but and I'm not going to break in a ton of new ground here either. You've heard 9, 10 people now say the same thing, but what I would point to, and I think Nicola touched on it, we don't have to guess on this, what happens when we reduce our jail population through releasing people, because we saw it when our public defender's office worked with our courts and the criminal division to reduce the jail population during COVID, and more people got out, the jail population dropped by something like 30, 40%, and it had no impact on people showing up for court. So we know what the outcome is when more people are released on their own recognizance. We just saw it this past year. The logic, I mean, cash bail collapses under the weight of its own logic. I totally agree with Lisa when she said, look, there's two, if you're a violent and danger to society, you don't get bail. And if you're not, then you don't go to jail. It's a pretty straightforward, algorithm there in terms of tautology, in terms of when you do it. There could be limited circumstances. I think mostly it's if someone is at flight risk or they have a history of ignoring court orders and not showing up. All right, then you definitely take that into consideration, and cash bail may indeed be appropriate. But I also agree very strongly that this is a magistrate. This is where this is imposed. Okay, this is where it's done. It is reviewed on petitions to the Court of Common Pleas, but that's where it's done and imposed in the first place. And I think that fix is legislative, and I think it has to be addressed either through who we elect as magistrates, or you can take it out of their hands and do it legislatively. When we're talking about these big picture policy issues on our state, judges don't make policy, they enforce it, they enforce laws, they apply laws to factual situations. And if we want to change policy on these sweeping issues like this, then we do need to do that to the legislative. I mean, we can proceed on all fronts, but that is where it has to get done. I'm generally in favor of giving judges more discretion, but that's an instance where we probably have to take it away if we keep seeing the same thing over and over again. On the issue of probation, I agree that we're talking about these sentences being imposed for the purposes of paying this restitution and fines and this stuff, and that has to be calculated on ability to pay. We charge things, taxes and other things on people based on their ability to pay every single day in this society. There's no logical reason why we can't do that on probation as well, and that would result in shorter sentences too. So I don't want to belabor points that have already been made, but thank you, and I look forward to teeing off round 2.
Thank you very much. Before we go to round 2, I just wanted to circle back to see if Jason Servone had joined us. Okay, and so we're going to move on to question 2. And remember, we will go in reverse alphabetical order this time. In 2012, the Supreme Court ruled in Miller versus Alabama that mandatory life sentences without parole for minors is unconstitutional under the 8th Amendment's ban on cruel and unusual punishment, citing that juvenile brains lack impulse control and proper executive function, and that their developing brains are much more amenable to rehabilitation. 4 years later, in 2016, the Supreme Court ruled in Montgomery versus Louisiana that the Miller versus Alabama ruling could be applied retroactively, meaning those who had been sentenced under the previous guidelines before Miller v. Alabama could still seek relief. On April 22nd, 2021, the current Supreme Court ruled that while mandatory life sentencing without the possibility of parole for a juvenile is unconstitutional, so long as the judge states that they considered the age of the minor, they can still sentence them to life in prison without the possibility of parole and without needing to find what is known as permanent incorrigibility. Supreme Court Justice Sonia Sotomayor wrote a dissenting opinion citing Justice Kavanaugh's own rulings and stated that the Supreme Court's ruling was, quote, contrary to explicit holdings in both aforementioned positions and distorted previous precedent, quote, beyond recognition. With this in mind, what is your position on the Miller v. Alabama ruling, and what would you as a judiciary do about it? In other words, do you think juveniles should ever be sentenced to life in prison without parole? If not, what do you think is the best course of action for handling serious juvenile offenses? If so, would you and how would you assess for permanent incorrigibility? And we will start with Andy Zeffi.
Thank you, Dee, I appreciate it. Just to start off, no, I don't think there should be permanent life without parole for juveniles on any offense. We see these standards in court. I have to marvel at some of them. I know that appellate courts sometimes have to sort of make up these words that the lower courts then have to discern. One of them I deal with every day through Monell claims against the jail and others, this county solicitor, is deliberate indifference. And it's one of these sort of pairings of words that themselves make no sense. You can't be deliberate and indifferent at the same time by definition. I feel the same way about permanent incorrigibility. I hope no one's permanently incorrigible. I have a hard time believing that those two words ever go together, especially when you're talking about juveniles. I have two 15-year-old sons, an 11-year-old daughter. Nothing that these children do is permanent from one minute to the next. Children are especially vulnerable to the circumstances around them and pressures and everything else. So to set up any system where there is any kind of life without parole for an offense, I think is profoundly misguided. And I do think what the Supreme Court did recently by sort of taking away that backstop of the state's burden to prove that someone is beyond rehabilitation at any point, especially in the sentencing of a juvenile at that stage, is also misguided. I mean, I think we see it in Pennsylvania where our Supreme Court set a standard that the state has to prove beyond a reasonable doubt that someone's beyond rehabilitation. That's hard to do. That is hard to do. What I would want to see as a judge, I'd need to see some serious psychiatric evidence to show me that this juvenile is beyond rehabilitation. That's an incredibly hard standard to prove. I think that's borne out in the stats in Pennsylvania, and Justice Sotomayor's dissent, she said, we see that in Pennsylvania at about 2% of the cases. I don't think there's many people out there that are beyond help. We call our jails and prisons departments of corrections. We call them that for a reason. I don't know why we'd punt on that optimism so early in the process. So no, I'm not in favor of any kind of non-reviewable permanent life without parole, really for anybody. I mean, the bar for that has got to be so high, and it's much higher when we're talking about juveniles.
Thank you
Thanks.
very much. I'm sorry. Thank you very much, Andy. Next, I will turn to Patrick A. Sweeney.
Thank you. Even only going second, I still would have to refer to Mr. Zeffi, the absurdity of the phrase permanent incorrigibility and trying to define that in some way without any guidance whatsoever from the Supreme Court is what our courts are faced with. I have, in my career as a public defender, had only 3 occasions to represent juveniles charged with homicide as adults. I've worked on some motions to get some cases transferred back to juvenile court before, but only one did receive life without parole, and that was, his case worked its way through the system and has pretty much been upheld from what I understand. I'm not a fan of life without parole for for anybody, quite frankly. I'm probably more against life without parole than I am against the death penalty, and I'm not crazy about the death penalty. The idea that anyone is permanently beyond redemption is difficult to wrap our minds around. However, in a homicide case where you've proven to commit the ultimate crime in our society, protecting society is something that our courts must do, and we must ensure that people, not only the defendants themselves who have broken these laws, are kept from breaking them again, but also a message is sent to everyone that this is the ultimate offense. When it comes to juveniles, I mean, I agree with a lot of the science behind it, having worked on a lot of these decertification motions over the years. I agree wholeheartedly with the fact that a 16-year-old and a 17-year-old is not the same as a 25-year-old in terms of their ability to wrap their minds around right and wrong and permanent consequences, and how that the damage they can cause to individuals and families is something that they need to avoid. So do I agree with the Miller decision? Do I disagree with the more recent one that just came down out of Mississippi, which made it easier for Mississippi to hold someone without parole? Of course. Do I think it should be applied retroactively? Absolutely. As an individual who would be tasked with sentencing, I would certainly take into account the science involved. I guess I agree with Roberts in some way in that decision. It's when you define cruel and unusual punishment, it's not unusual when almost every state in the union does it, but is it cruel? I think yes. And I think Pennsylvania and our courts should not be holding people permanently, defining them as permanently incorrigible when there's some other option available. So I hope that answers your question.
Thank you. It does, Patrick. Next, I will move to Jimmy Sheets.
Hi, Dee. I'm back. Listen, as far as juveniles and life sentences, I am absolutely opposed. Okay, I have fortunately had the opportunity to represent more than a few juvenile defendants in my 20-year career, both as a public defender and in private practice. And the science is what it is. And, the fact that the Supreme Court has said on more than one occasion and in more than one case that it is cruel and unusual punishment to sentence juvenile offenders to life in prison when developmentally they're incapable of having that level of responsibility for their actions. As a jurist, I would again, follow the law, and the law in this case is that juveniles are not to be sentenced to life in prison. I don't think anybody is incorrigible to the point that they have to be sentenced to life in prison as a juvenile. And I have fought against that as a representing juveniles. Certainly they are to be treated differently as far as I'm concerned. We do an awful lot in adult court with diversionary programs and everything else. We ought to be doing even more for juvenile offenders in the system. And, again, if given the opportunity to serve on the Court of Common Pleas, I would bring that philosophy with me to the bench.
Thank you very much, Jimmy. I appreciate your comments.
Thank
Next,
you.
we'll move to Jesse Rosselli.
Hi, Dee. It's Giuseppe, but that's okay. So I too have represented a juvenile who was not only accused of homicide, but was ultimately convicted of first-degree homicide. I believe, and it was reported locally, that the sentencing for my client, which I also handled, was the first of its kind post-Miller, and was the first individual not to receive a life sentence after a conviction on first-degree murder. We all bring our own experiences to this conversation. And let me start by saying, under no set of circumstances should a juvenile be sentenced to life without the possibility of parole. But we all bring our own experiences to this conversation. And when you sit across the table from a 15-year-old who has been charged with the killing of another, and you're discussing trial strategy, and you're discussing legal argument, and you're looking for guidance from your child client as to how to best help them. And you recognize that the person sitting across the table from you likes to play video games, right? Likes to play basketball with his friends, doesn't understand the process that he's engaging in. The idea that any person in that situation with that limited growth and life experience should be exposed to a penalty where there remains no hope. That can't be part of our system. We cannot accept that. That should not be part of what we do. Kids should be treated as kids, regardless of the conduct. If we accept the fact that they are not fully developed until the age of 25, what they have done should not be relevant to the conversation. We should be treating them like children. We should be providing them with an opportunity to first work through the juvenile system. Now, some will say, well, the juvenile system can't deal with some juveniles who come through adult court, and I can appreciate that. But the idea that at the end of that process, at the end of a sentencing hearing where all of the relevant information has been provided, the idea that the conclusion could ever be that that child is going to spend the rest of their life in prison, it's unacceptable.
Thank you very much. Next, we'll move to Matt Rogers.
Thank you. Yeah, I think pretty much all of us are going to be of this, at least a relatively similar mind when it comes to this type of issue. The psychology and the science really just bears out that adolescents are far more likely to act on impulse, to get into accidents, to get into fights, to engage in risky behavior, just because of their mental development. They're less likely to think before they do stuff, to think about the consequence of their actions, or like change these behaviors because they can see what the consequences might be. And to treat individuals with that cognitive development in the same manner as we treat fully developed adults is obviously fundamentally, unfair. And to consider that these individuals are not able to be rehabilitated or be receptive to treatment is frankly ridiculous. 99.9% of these cases are handled across the street in the family court rather than in the criminal division. And I don't really see any, I understand it when the district attorney makes the decision to prosecute based on, by treating that individual as an adult, it's sort of out of anybody's control at that point. But the juvenile section in the family division is far more, I think, well equipped to handle these issues and should be relied on as exclusively as humanly possible, rather than subjecting these children to a trial in the adult court and the prospect of a life sentence. I mean, fortunately, with Miller, there's still the opportunity for each judge to sort of use their own discretion when it comes to sentencing. It does unfortunately open it up to making it easier to issue a life sentence, which is unfortunate. But I mean, just as long as there's that discretion that's there for the court to say, listen, if one of us reaches the bench, if I reach the bench and this, such a situation comes before me, say no, the Commonwealth is asking for a life sentence. I don't think that's appropriate in this or maybe any other case. And I think that some less restrictive alternative that's more rehabilitative than punitive is more appropriate.
Thank you very much, Matt. I appreciate that. Next, we'll turn to Zeke Whitaker.
Thank you, Dee. I appreciate it. I actually, when I saw that your group was going to be asking about juvenile life without parole, I was excited and I was really eager to discuss this issue because it doesn't come up that often on the campaign trail. And this is an area where I've done a lot of work. So just to take one step back, I have been working on criminal justice reform issues for years now, but after George Floyd was murdered, you guys probably saw every company in America begin talking about their commitments to racial justice. But I wanted to make sure that as lawyers, and my law firm particularly, we were actually going to walk the walk and not just talk the talk. So we've been working to establish a permanent, firm-wide criminal justice reform pro bono program. And a big part of that is working on juvenile life without parole issues. I'm working on a case right now that involved a teenager who killed somebody during a drug deal gone bad, was convicted, and then received as a juvenile a sentence of life without parole. He's been in prison for 35 years. And during that time, he has had a very good record. He is somebody who has reformed himself, somebody who's an avid reader, somebody who takes part in activities, somebody who's committed to fitness and all of these different things that we associate with reformation and real rehabilitation. I think that when we think about these very serious crimes, it's easy to think of people in a way that can be dehumanizing, but ultimately I believe that a person is better and more human than the worst thing that they've ever done and the worst day of their lives. And I think these juvenile life without parole cases show that over and over and over again. You know, the opinion that was penned by Justice Kennedy really gave a lot of advocates in this space hope that we would be able as advocates to get more juvenile lifers out of prison and actually give them a real second chance after they had committed this crime. But what we saw happen in Jones versus Mississippi, which came out recently, was the Supreme Court partially, if not fully, closed the door on a lot of that progress in a 6-3 opinion that was penned by Justice Kavanaugh. I think right now, what we're waiting for in the case that I'm working on is the Pennsylvania Supreme Court to actually decide what constitutes a life sentence in the case of juveniles. Some state Supreme Courts have come out and said that it's 25 years. Some have come out and said that it's 20 years or 30 years or 50 years. But we just don't know. And in our case, that's the difference between trying to get a resentencing under Miller and having to go through the parole process and actually being able to say, look, here's the deal. He has done his time. He has done a life sentence according to the Pennsylvania Supreme Court, and he needs to be let out of jail immediately so that he can resume his life. I'm proud to have worked on these issues. I think that they're really important right now. And I'm sincerely hopeful that when we elect 9 judges on the Court of Common Pleas this spring, especially to the criminal division, they will be people who also understand these issues, that are committed to criminal justice reform, and are also committed to letting children have a second chance, even after they've done something horrible that has affected society.
We need to wrap up. Thank you very much. All right.
Thank you.
Thank you very much to our wonderful timekeeper, but thank you very much, Zeke, for your comments here tonight. Next, we will be moving on to Lisa Middleman. And again, the question is, in other words, do you think juveniles should ever be sentenced to life in prison without parole? If not, what do you think is the best course of action for handling serious juvenile offenses? If so, would you, and how would you assess permanent incorrigibility? Thank you, Lisa Middleman.
Sure, thanks. So just some background for folks who might not understand. The Supreme Court of the United States decides whether state statutes are constitutional or unconstitutional. So they may say that something is acceptable, but Pennsylvania might say, no, we want to give the citizens of our state more protection than the federal government gives it. So a decision made by the Supreme Court sort of sets the worst case scenario. And then Pennsylvania is able to make their own laws as long as they don't infringe or go any further than the federal laws. So what the Supreme Court of the United States said was that you don't have to say somebody's permanently incorrigible in order to give them a life sentence if they're a juvenile. You can give them a life sentence. Now, the Pennsylvania legislature can certainly make different laws and pass different statutes that will prevent that. They haven't done that, and that obviously is the purview of the legislature. In Pennsylvania, though, we do have two situations where a life sentence must be imposed, and that is if an individual is convicted of first-degree murder or second-degree murder. And in Pennsylvania, life is life without the possibility of parole. So I guess what you're saying, it seems sort of ironic that that Pennsylvania legislature would say, okay, we think that people should go to prison because we think they should be rehabilitated and we can make them better people. But then they also say, yeah, but we're not very good at that. So there are some people that we're just going to have to keep locked up there forever. Like, it doesn't make any sense. And particularly with children, like, we know that the frontal lobes of children do not develop fully until they're 25 years old. And you cannot even diagnose, according to the DSM-5, you cannot even diagnose an individual as being a sociopath until after they're 18 years old. So why on earth are we saying we can decide that somebody at 15 years old is somebody who can't be redeemed? It's nonsensical and it doesn't make any sense. And it also demonstrates the reason why mandatory sentences are so bad, because they take the discretion away from the judge entirely. You know, you may have a child who at 17 years old has demonstrated that they are incapable of rehabilitation. I've never seen that happen, but as a judge, I don't think you can say never, and I don't think you can say always. But most children are known for being more amenable to rehabilitation than adults. The difficulty is for people sort of viscerally to accept a child who's committed a heinous crime or a horrible crime only spending 3 or 4 years in treatment. So if you have a child who commits a crime when they're 17 years old, you can only keep them in treatment until they're 21. That's 4 years. We need to work, the judges who are elected need to work with the legislature to raise the age that we can continue to give somebody who has been sentenced in juvenile court treatment at least up to 25 until their brain is finished developing. And then that way we might be able to do, and I see my time is up, but maybe one of the candidates following me will take that ball and run with it.
Thank you very much, Lisa. I really appreciate your comments. Next, we will move to Brian Samuel Malkin.
So first of all, I believe Miller versus Alabama was decided correctly. I think that automatically rendering a life sentence on a juvenile so that they're unable to get parole is unconstitutional under the 8th Amendment. I think everybody agrees on that. Now, if you take a look on Montgomery versus Louisiana, a judge may review the sentence of a minor who was sentenced before Miller versus Alabama was decided. And in footnote 2, Justice Sotomayor points out in her dissent in Jones versus Mississippi, which has already been mentioned, that the racial disparities in juvenile life without parole sentencing are stark. 70% of all youth sentenced to life without parole are children of color. So Miller at least gives a sentencer under state law a chance to consider all the factors, and that may lessen the disparate impact on children of color. So the next question to kind of talk about is, how do you assess permanent incorrigibility? So after Miller was decided, Pennsylvania instituted new sentencing guidelines for juveniles who commit murder. They required the sentencer, the judge, to consider more than the age of the offender. Also, Pennsylvania creates a rebuttable presumption that life without parole sentence imposed on a juvenile is illegal unless the defendant is found to be forever incorrigible without any hope of rehabilitation. In an 85-page post-Miller decision issued by the Pennsylvania Supreme Court, Commonwealth versus Batts, the court explained that the presumption against the legality of life without parole must be rebutted by the state by evidence beyond a reasonable doubt in order to impose life without parole on juveniles. So in Pennsylvania, that has resulted in less than 2% of resentencing to life without parole for juveniles. I would certainly follow Batts in assessing permanent incorrigibility. And one needs to look at all the mitigating and aggravating circumstances of the child's crime. The judge should be aware of all the psychologically and physically damaging factors that may have led the child to commit the crime of murder. Expert testimony analysis has to be heard. A review of the criminal history, seriousness of the prior offenses of the juvenile, prior probation reports, current probation, in short, all the factors and circumstances that lead to this juvenile to commit the crime, and all the predictors that as they mature and their judgment and impulse control solidify, they'll become or have become different people willing and able to contribute to society. And recently in the US Supreme Court, led by its conservatives, issued Jones versus Mississippi, holding that a finding of permanent incorrigibility is not needed to sentence a juvenile murderer to life without parole. It's important to note the US Supreme Court sets the floor for constitutional protection, as Ms. Middleman said, and states can do as much as they want beyond that. Here in Pennsylvania, we're doing the right thing as set forth in Batts. I think that Justice Sotomayor in Jones puts it correctly. The question in these juvenile life without parole cases is whether the state at some point must consider whether a juvenile offender has demonstrated maturity and rehabilitation sufficient to merit a chance at life beyond the prison in which he has grown up. For most offenders, Justice Sotomayor points out, the answer is yes.
Thank you very much for sharing that with us. Next, we will move to Nicola Henry Taylor.
So like everyone else, I agree that juveniles should not be sentenced to life in prison without the possibility of parole. Judges should have discretion in looking at the totality of the circumstances and all aspects of the case. I work in family division on a regular basis, and I'm really happy that we're having a discussion about children. I think the social justice issues and the criminal justice issues are important, but we must not forget about these children. And we see from the Alabama v. Miller case that how important children are. Some of the things that I love about doing delinquency cases or even dependency cases is we're looking at treatment, we're looking at restorative justice concepts, and we have an opportunity, and I've seen a turnaround in children when we give them the proper supports and the proper treatment. And even in these cases that are heinous, as Attorney Middleman stated, there is an opportunity for treatment and for change and for a productive life, because ultimately that's what we want. We want people, we want children who will be a productive part of our society. So, and others have talked about why we shouldn't be looking at children as adults. We should be looking at the individual characteristic of this child. We must not forget they're children. As Attorney Roselli said, they're thinking about playing video games. We must not forget that they come from broken homes. They're cycling with delinquency matters and all kinds of abuse and trauma that goes on in their homes, and they are immature. They have not been fully formed. They have not reached their age of maturity. They're also vulnerable, and they're vulnerable to the negative aspects of their peers and others who they may look at as role models. If they don't have the proper parents in the home, the proper structure and the proper, they may not be lucky enough to come from a community that gives them the supports that they need. I already mentioned that amenability or changeability is really important. And that's what's nice. In Pennsylvania, our juvenile statute affords that. And we must not forget about that even in these important cases. In addition to extending past the 21 supervision for juveniles, another thing that we could consider is, instead of a criminal court judge hearing cases with juveniles, having a family court judge hear the cases. I remember a case on an Act 33 case where juveniles was charged as an adult, and the judge who handles them usually has a status conference. He has this all in his courtroom, and a couple of us, the attorneys, made motions that the cases be heard in front of a juvenile judge, and while the judge was open to it, he said, well, that's not how we do it. Until Judge Clark tells me otherwise, we're not going to do it. So let's think about that, because that is something we can do. And as we've discussed through a number of the candidates, the judges in Allegheny County can be proactive, and there are things that can be done. So let's think about that.
Thank you very much. And last but not least, for this question, we will turn now to Bruce Beamer.
Thanks. It's a great question. The bottom line is Miller v. Alabama was rightly decided. I just want to talk a little bit about a couple of issues that I think are that have been touched on, but I think are really important for everybody to remember when we're talking about this issue. Pennsylvania had more juvenile lifers than any state in the United States. And part of the reason for that was a complete inflexibility in the way that we do things. First and second degree murder, as Lisa Middleman correctly pointed out, the penalty was life without parole. So let's talk a little bit about what we're talking about. We had hundreds of juveniles in prison with no hope of being paroled. And in many of those instances, they weren't even the principal accused of the homicide. They may have been an individual who went on a drive with 2 or 3 other friends and was sitting outside in a car when there was a robbery inside of a store and somebody got shot and killed inside the store. And if they were convicted of second degree murder, they were serving a life sentence without the possibility of parole. So when you combine that with the fact that the science shows us that juvenile offenders simply are not developed the way adult offenders are, you have a system that's ripe for all sorts of injustice. Miller goes a long way, as do the cases that follow it. And we just hit a little bit of a snag, obviously, that it was described in the case out of Mississippi. But Pennsylvania needs to work on a system that addresses that sort of equity in sentencing, that recognizes that there are, with respect to juvenile offenders, that you should be fashioning sentences that are individual to those offenders, even in the worst cases. Because even in the worst cases, in Pennsylvania, the way we sentence is we have a minimum sentence and a maximum sentence. And an individual should have the opportunity to be up for parole at some point down the road. And it should be at a time when as the parole board can look at them and see how they did in and how they are doing in prison in terms of their ability to reform and do better. The idea of permanent incorrigibility when it comes to juveniles is incredibly misguided. I think it's terribly wrong. Mr. Zeke Redeker made a really good point as it relates to when you're looking at issues surrounding parole for juvenile offenders. Let's look at how they are doing. If you have somebody that's been in prison for 30 or 35 years, it seems, and they have shown that they are amenable to rehabilitation, it seems unbelievable that they were under the age of 18 and are still sitting in jail without the opportunity to at least be released. So those are, I think that things that we need to constantly keep in mind, that the vast majority of those individuals, not only are we talking about individuals that are not permanently settled in terms of the way that they've developed, but a lot of times they're charged with homicide crimes. And in those situations,
Bruce, we're going to have to cut you off. I'm so sorry. Thank you so much. And we've now got a little time for Q&A, which is wonderful.
Thank you, Cindy. Thank you, Bruce, very much for your comments here tonight. And thank you to all the candidates who have shared their comments with us tonight. I agreed with many of them. Not only do we really appreciate your time, but we really appreciate your accessibility. And we felt it was really important to have judicial candidates comment on these key issues. As a reminder for everyone, the primary elections are on May 18th. So please refer to the links that Lauren put in the chat earlier for more resources about that. We do have about 15 minutes here to return to questions. I am happy to keep the session open a little longer at the end if any candidates would like to interact with the audience at the end. Before I do so, I just want to say thank you so much to Dr. Cindy Lacombe for keeping things on track and running smoothly this evening. And thank you to Lauren Courtwright, who worked really hard to put this event together with me, and for her diligence as a visual moderator. Thank you to the Think Tank for Restorative Justice, the Duquesne University Sociology Club, the House of Life, and Slippery Rock University for co-sponsoring this event tonight. And last but not least, for being an inspiration and for helping us ask the tough questions, I want to give a special thank you to Charlie Lewis. Please join us again tomorrow night at 7 p.m. for a session where 10 other candidates will share their thoughts. I'll now turn to the questions that have been submitted by the audience. For this portion, we'll go back to regular alphabetical order, and we'll give about 1.5 minutes to each candidate. Some of the questions that have come in here, and I'll kind of let you guys decide which ones you'd like to comment on. How do you understand danger to the community? We heard that brought up a couple of times tonight. What does that exactly mean? And then in regards to the Common Pleas Court, what do you see as the most pressing issue at this time for a candidate in your position, and what do you want to do about that? I'll bring some more questions up as they come in. And so we will first start with Bruce Beamer again. Thank you.
Okay, so just to be clear, do we have 1.5 minutes to answer those two questions, danger to the community and?
You can do danger to the community first. I think if we have enough time, I can circle back. I just know that there's only about 15 minutes, and I wanted to be considerate of everyone's time.
Sure. So danger to the community is something that we have to look at, particularly with pretrial bail issues, and we look at a number of different things, which is what is the nature of the offense with somebody is charged? What is the strength of the evidence that is against them? And we do this in a bail hearing. We also look at any prior history of violence and whether or not a particular individual may be in jeopardy or danger from this particular individual, whether it's a domestic violence case, whether it's a case that involves offenses against children, or whether it's a case that involves some sort of level of violence or a weapon of some sort. So you look at all of those circumstances in determining whether or not somebody is dangerous to the community. And somebody said it earlier, and it's a really good point. I think it's really important to keep in mind, if somebody's truly a danger and the prosecutors can establish that, then that's one thing. But setting a really high cash bail only says that the person who has more money is able to pay that, where somebody who doesn't isn't. And so that's one of the real issues, and why looking at somebody's dangerousness is so important.
We do need to move on, and I know that 90 seconds, I wish I didn't have to keep putting 30 seconds in the chat. 90 seconds, this is a good problem to have. We just don't have enough time. So, thank you.
Next, we will move to Nicola Henry Taylor.
In assessing dangers to the community under the bail factors in Pennsylvania, the court will look also at the person's prior criminal history. However, from the discussions that we've had, we know that certain communities are over-policed, and that certain groups, such as people of color, end up having more charges. There's a concept called the broken glass concept, where something simple like a small amount of marijuana or a taillight out escalates into more serious charges. So even though that's a factor, I would just caution that when we're looking at that we understand that there are implicit biases that could come into that decision making when we're looking at people's prior criminal history.
Thank you very much. Next, we'll move to Brian Malkin.
Briefly, I think people touched on the factors that talk about danger to the community. I think that you pretty much listed the issues, the seriousness of the offense that somebody's accused of, their prior criminal background. The other things that we should look at, obviously, are their connections to the community, whether or not they're a flight risk. These types of things all should go into the decision-making process. And it's really trying to predict which is very difficult. And especially in over-policed communities, as Ms. Nicola Henry Taylor has alluded to, things can escalate very quickly, and you wind up with somebody who had a bad day now being in front of you on an issue of whether or not they should be held or released. It's very difficult. So thanks.
Thank you very much. For the questions here on out, we're starting to get a lot more questions in the chat. I will just pose a new question as they come through to each candidate, and I'll be sure that I get a circle back around for the candidates who didn't get to answer their own type of question. For our next question, this is going to be posed to Lisa Middleman. In regard to question 2 that was asked, can any candidates provide a more specific best course of action for the judiciary?
Are you referring to the juvenile homicide cases?
Yes, we are. Thank you for
Okay,
making
well,
that
that's
clear.
actually a fairly good question for me, since that's I'm the first woman at the public defenders to be in the homicide unit. So I've been doing homicides for a very long time. And there certainly is an argument to be made that an individual who has killed another individual may pose a danger to the community and thereby needs to be incarcerated to keep the rest of us safe. However, if you believe that the purpose of incarceration is also to rehabilitate someone and to reform them and to allow them to sometimes even just age out of violent behavior, which we find happens very frequently with young children, then you have to provide the opportunity for a future, and you have to allow that the person will be more motivated to improve themselves, to finish school, to cooperate with therapy and treatment if you allow them the potential to get out of jail. So I don't have a problem with a maximum sentence that allows for the parole board to make the decision as to whether the person has been properly rehabilitated, rather than some arbitrary judge at the onset of their incarceration. So let the people making the decisions actually evaluate the person's progress. And so the minimum sentence should be low enough so that the individual has some incentive to achieve, and the maximum sentence should be high
Lisa,
enough.
I'm going to have to interrupt. Sorry. Thank you, though.
Thank you very much. Our next speaker will be Zeke Redeker, and your question is, how do you plan to protect minorities in the application of the law?
So I think we've already had a great conversation about cash bail, which has been shown to disproportionately impact communities of color. But another area that's really important that also relates to juvenile life without parole is sentencing. One of the most important things that a judge does, judges in the criminal division specifically, is they get to choose to take away somebody's liberty, and they get to choose for how long. And I think one of the most important things a judge can do is actually try to get to know the litigants as people. And that means taking the time and working hard to try to understand what their background is, what issues they've faced, and what are the facts of the case. I clerked for the federal trial court in New York City. And the judge that I worked for, I remember watching her pore over pre-sentence reports and literally every bit and shred of information that she could find about individual defendants that she would sentence, because those are the most important issues that a court can make, is to take away somebody's liberty. So, when it comes especially to marginalized communities, communities of color, low-income communities, judges, there's a special burden on judges to try to get sentencing right and using their discretion in the right way. Dee, I think you're muted.
Thank you. See, it happens to the best of us. For the next candidate speaking, we will have Matt Rogers, and your question is, what do you see as the most pressing matter for a judge in the common pleas court right now?
Well, I mean, there are a lot of different issues that are sort of facing the court, like among the various divisions. I mean, the biggest thing is sort of the inequity of treatment across the board, whether it's people that have and do not have means, or those of a minority status. there's a clear inequity of treatment by the court with respect to those that are minorities and then don't have the ability to hire representation for themselves. And what has to happen from the judiciary standpoint is, it has to be sort of your proverbial come to Jesus moment, right? Like the judiciary has to recognize that there is a problem and be willing to be honest with themselves and admit it, first of all, and then take the appropriate means to make changes with respect to how certain individuals are treated, how they're sentenced, how they're spoken to by the court, just in if they're pro se litigants that are dealing with the court. So I think just a simple recognition that there is a problem, understanding how to address it, and being honest with ourselves is really the biggest thing that's before us these days.
Thank you very much for your comments. Next, I'll be moving to Giuseppe Rosselli, and I really hope I said that correctly this time. And your question is from another audience member, and it's surrounded around the idea of legislating from the court. She's concerned that this might be a possibility in some of the things that have been proposed here tonight. What are your thoughts on that matter about legislating from the bench?
Yeah, I think it's a fair question. I think anytime you bring people to the table who are looking to make change, the gut reaction is that somehow that makes you an advocate from the bench or you're trying to create law. The reality is that many of the things that have been proposed during the campaign, whether it be how we deal with cash bail, how we deal with probation, that's not a legislative issue. It doesn't have to be. There are things that we can do to improve our situation in those areas. At some point, sure, legislation would finalize these issues, but as judges and as a collective of judges who have a unified voice that see these issues and the dangers of these certain policies, there's strength in numbers. And if we have enough progressive minds in these positions who want to deal with these issues, we can start making the changes from within, and we'll let the legislature catch up with us.
Thank you very much for your comments as well. Next, we'll be moving to Jimmy Sheets, and your question is, do you believe that there is such thing as a victimless crime? If so, what offenses would you place into this category?
Jimmy, you're muted.
I don't believe that there's anything that can be referred to as a victimless crime. Sometimes I believe that the victim is also the perpetrator. People would say, well, retail theft or drug use, or, even prostitution is a victimless crime. But there is a victim, and that may be, in fact, the perpetrator. And so in those instances, I think we have done a good job. We need to continue to do a better job of addressing the needs of both the perpetrator and, to follow my logic, the victim, in providing things like we do through the diversionary courts that we have right now in Allegheny County. Drug court, DUI court, a mental health court. We even have prostitution court with the Pride program to help people involved in the sex trade improve their situation. So no, I don't think there's any such thing as a victimless crime, but I think sometimes the victim is also the perpetrator, and we need to do what we can to address the underlying issues.
Thank you. Perfect.
Thank you very much. Next, we'll be moving to Patrick A. Sweeney. And your question is, what is your position on mandatory minimum sentences, and can anything be done about them by the judiciary?
My position, just in terms of a voter and as somebody that might want to be a judge someday, I'm not a fan. I see, as a practitioner, as a public defender, and somebody that represents people that are often staring at a mandatory, what they do policy-wise is coerce pleas and coerce cooperation, which may not entirely be honest. And I don't think it serves the interest of justice. I've had many clients over the years accept a plea agreement to avoid the hammer coming down because of a potential mandatory minimum sentence where we might have had a good case to take to trial. So I think you end up with innocent people pleading guilty to things they didn't necessarily do because they don't necessarily feel they can win at trial, and that's works against the interest of justice. In terms of what can we do about them, I think it gets back to that question from a couple of answers ago. Can we legislate from the bench? I think we can be advocates, of course, to move away from mandatory minimum sentences, and if they are in of themselves cruel and unusual, or at least cruel, we can rule in that fashion. But that's really up to the legislature who passes mandatory minimum sentences, and not up to the judiciary.
Thank you very much. And last but not least, we will turn to Andy Zeppi. And your question from the chat is, to my understanding, there is some form of judges training program for new judges they must be a part of before taking to the bench. Is this training relevant or sufficient? Does it actually help, or should there be other ways to educate new judges, or is it actually needed at all?
That's a good question. As someone who's never been to it, I'm just going to guess and tell you what I think should be included in it. I think this is one of the reasons we should elect some people with real experience, who've been lawyers for a long time, who've been in court and practiced law for a long time. You know, baby judge school, as they call it, I think is there's some value to it because judges are trained across all divisions. I think one thing that we really have to concentrate on that I know it's mandatory in Minnesota and there's some other states is implicit bias training for judges and their staff. And that is on a recurring basis. Every one of us on this Zoom call, every one of us in our society has them, and we need to proactively address them every day. And I think that starts, you know, and judges are no exception. Judges have them too, obviously, just like everyone in their courtroom does. So that has to be addressed on an ongoing basis. You don't take one seminar, you don't have a day in baby judge school and you've fixed all your biases. It's not how bias works. It takes constant effort to address and recognize. With regard to the rest of it, I think it is a good idea to go, you know, because I think no lawyer does everything. We all have concentrations and areas of expertise, but you might be called upon in any division to practice in there. So yes, it's a good idea. I think it needs to be expanded in certain ways, implicit bias being one of them.
Thank you very much. Amazingly, we stayed so perfectly on time. Everybody had such amazing comments. We are right just about at 7:30, 7:32. I wanted to again say thank you so much to everybody who was here listening and learning, but thank you so much to the candidates for joining us, for the people who helped me put this together and make this possible. And I really hope to see all of you guys join us tomorrow evening at 7 p.m. to see the other 10 candidates who have RSVP'd to have their position stated. If there's anybody that would really like to ask questions for any judges that might want to stay behind, I'm happy to leave the Zoom open for 10 or 15 minutes if anybody would like to ask questions, but there's no pressure to that. Thank you everybody so much.
Give Cindy a raise. She deserves it.
She sure does.
And I want to say thank you, Dee and Lauren, for all the work you did, and Charlie for being who you are. So thanks. And thanks to every candidate who joined us tonight.
Thank you.
You guys so much for having us on.
Thank you so much.
I would like to thank
Good night,
all of
everybody.
you for
Thank
being
you.
here. It kind of means a lot. I have questions for all of you that I guess there's not enough time. And I would really like to pick your brains over it. You understand what I'm talking about, you know, especially about the juvenile life.
I've got a minute, Charlie, if you have some questions.
Okay. Okay, on the juvenile lifers. How can I've been in court before. I know a little bit, you know, and the case that came down from Mississippi, just this recent one. It seems like the justices really don't care. The Supreme Court justices, it seems like they really don't care about understanding juvenile brains. You know, I mean, the juveniles they know it's a crime, but they don't understand the consequences of the crime that they're doing, and it's wrong to sentence them to life whenever they really don't know what they're getting themselves into. I mean, a life sentence no one should be sentenced to life. If you can't do good after 20 years, shame on you.
Right.
20 years in prison, I mean, there should be a limit. There isn't, and nothing you can do about it. And it's just like, tell me something. Is parole and probation, is that a sentence? Yes,
So-
it is.
Yes.
It's another sentence. When I got out, I overturned my case and I got out. And the judge said, well, I'm going to give you 5 years paper just to keep an eye on you. I said, you're giving me 5 years parole just to keep an eye on me? Well, parole is a sentence.
Didn't you already have parole and he gave you
No.
consecutive probation?
No, I overturned my case. And he wanted to give me 5 years paper. After I overturned the case, he wanted to give me 5 years paper. And I said, for what? He said, well, you're institutionalized. Well, Your Honor, I didn't institutionalize me. You institutionalized me. Now you're giving me a sentence for something you did.
Right.
That's why I started this off saying, is parole and probation a sentence? Of course it is.
Right.
And it's just like with the juvenile lifers, they're giving them, some of them are getting let out. Okay, fine, good, very good. But they're giving them lifetime parole after that. I mean, it's just like George Floyd. They're saying, you have your foot on my neck, get it off.
Right.
And that's exactly what they're doing. And then, you go down the street. Pardon me?
Charlie, these are like really good points that I hadn't really considered before. So I would just like to ask, I know you said is that a sentence, is giving probation a sentence? So it seems like what you might be asking is it possible to create like a secondary sentence where if someone I guess maybe if they have been given a sentence of life without parole, and then once this got changed and now they're able to get parole, is it a second sentence to then assign parole to them after, or do they just have to be let out at that point? Is that kind of the question you're asking, Charlie? Because I'd be interested to find out.
Yes. I mean, if they overturn the case, give it back or whatever, and then they're getting parole for lifetime parole, that's another life sentence.
Well, if you are sentenced and then your sentence is found to be an illegal sentence, as all the juvenile life sentences, mandatory juvenile life sentences were, then the judge is basically starting from scratch to sentence you. So the judge could give you another life sentence if he wanted to. It's just that the mandatory part of it was deemed to be unconstitutional. So when that mandatory life sentence was vacated, the judge had all of the sentencing options available to him that he had initially. And so it seems grossly unfair given the amount of time that an individual has usually spent in jail at the time that their sentence is vacated, but it's perfectly legal. Perhaps, that is something for the legislature to consider. What should a future life sentence look like? Or what should the penalty actually be for first or second degree murder? In a lot of states, life is not life without the possibility of parole.
Thanks.
A lot of
Lisa.
states, it's like would be 25 years.
Lisa, can I ask you a question? So you started talking about, and I was working on this in preparation for tonight's forum. Sort of this missing component, between juvenile court and adult court for dealing with individuals who are dealing with serious offenses, including murder.
Well, you have an idea about that.
Say again?
You have a very good idea about that. My idea was about allowing juveniles to continue their sentence when they're adults, but I think you have a very interesting idea about people in that range between 18 and 25 years old, don't you?
Yeah, I think there's a missing component, and however we structure it, whether it's an extension through juvenile court, or whether it's a creation of an entire entity that consumes those types of cases. I think lawyers like you, myself, Mr. Rogers, if given the opportunity, these are things that we need to be talking about in those rooms when it's time to figure out a solution to this very difficult problem.
Because I think that, if you have a child who is a juvenile and has committed a crime and needs a significant amount of therapy or treatment, juvenile jurisdiction ends at age 21. But the child's brain is still developing after that. We have an opportunity for 4 more years. But the current juvenile setup is that he's finished with the entire system at 21. It'd be nice to extend, but that's once again a legislative it's the function of the legislature.
And isn't it interesting that it's the legislatures who don't do juvenile murder cases who are tasked with creating the processes to deal with juveniles accused and convicted of murder?
And that's actually sort of an introduction to the direction that I was about to go about, what we talked about the fact that the brain development doesn't necessarily end until, or become fully developed until 25. And we have the criminal justice system that will try a 15-year-old as an adult, and the juvenile dependency system doesn't even end until 21. For God's sake, if there are certain developmental issues, you can get child support, essentially indefinitely, but they're still going to treat, maybe if they're so severe, the criminal justice system will treat them differently. But like the fact that a 15-year-old can be tried and convicted of murder and sent to prison for life sentence, but in other areas of the court, we're so much more willing to be lenient and to be understanding. But when it comes to the most serious offenses, we're like, no, sorry.
Yeah, because it's easy to make those other decisions, but when forced to make those most difficult decisions, people tend to fall back and they blink, and they understand that the decision that they may be making is not going to be a popular one. And go ahead, Charlie. I'm sorry.
I just wanted to mention in the first question about the bail and everything, not one of you mentioned anything about house arrest or using a bracelet.
Yeah. So
no one mentioned that though.
Yeah, I was going to, but that for me, that is more of an issue as it relates to flight. Is someone a flight risk? And as we heard before, it's 90% of the people who are released without a bail come back. So I'm far less concerned about making sure people come back, because they do. I'm far more concerned about individuals who are deemed dangerous. And that's a tricky question because it brings in our own implicit biases. Who is dangerous, right? And
I mean, you're talking about the poorer people and everything have to go to jail because you can't get bail. Why aren't they offered the house arrest or the bracelet?
Yeah, what I'm suggesting is, what I'm suggesting is, if they're dangerous, they're dangerous. I don't care if you have money or not.
I think what you're missing, the piece you may not know, Charlie, is that every single day on house arrest costs the person on house arrest $5 a day.
Correct.
Yeah, they charge you $150 a month to be on house arrest.
That's better than being in jail.
Yeah, I don't know. For most people, it probably is. I think that I'm sorry. So yeah, I think for most people, house arrest might be better than jail, but then you end up at the end of your case, what if you were on house arrest during COVID? There's some cases that have been, people have been sitting for 12 months now. So they would be in a lot of trouble financially
But they could also keep their job.
I have a question about that, and this might be an ignorant question, I'm just not sure, but it came up in listening to you just now. What about people who might be like on house arrest but have like a dangerous partner or like a domestic abuse type of situation? What would happen to somebody who would be confined in the house with somebody that's maybe not safe for them without an escape away from them.
Well, they can escape. The alarm would just go off. You know what I mean? You just wear an ankle bracelet. It would alert your probation officer.
Right. Yeah, Lisa's totally right. I mean, that happens. You know, I deal with that with PFAs, you know, things like that. It's a thing that like comes up occasionally where you're in a bad situation and, you know, youthfully alarm goes off, you get picked up, and your probation officer is alerted, and no judge is gonna begrudge you from fleeing a dangerous situation. So they're not gonna consider that a violation. So.
Are there any other questions from any of the other people that have stayed on here tonight? For myself, the last question I would like to ask is if there's any issue that you think is specifically pressing, especially for a common pleas court judge candidate, that was not mentioned here tonight that you think should have been mentioned.
Can I jump in? Yeah, so look, I think we have a criminal justice system that is far too punitive and focused on punishment and not focused on rehabilitation, not focused on protecting our most vulnerable citizens who come through the system. Right now, we have diversion courts in Allegheny County, and they're wonderful programs. They really are. And I hope the direction of our justice system is diversion first, you know, and punishment second. And what I mean by that is, here in Allegheny County, we have DUI court, mental health court, drug court, and veterans court. In each of those courts, we've identified underlying contributing causes to criminal behavior that we deem worthy to provide resources rather than prosecuting to the fullest extent of the law. So we're going to try to build these individuals up because we understand there's an underlying cause that has brought them into the system. But we fall short in three very specific areas. The first is we don't acknowledge poverty and lack of opportunity as a significant enough contributing cause worthy of resources. So we need to expand the types of individuals who we're bringing into our diversion programs. The second thing is that when you come into the diversion programs as they're currently constituted, your next step must be jail. So we divert in Allegheny County from jail. But what that means is you've been through the system 3, 4, 5 times, right? And it's only until that 4th, 5th time that you're getting the resources that are available. I believe we should be starting much sooner. When you come into the system for the first time and we've identified an underlying contributing cause, we should provide those resources as early as possible. And last, when you work intimately with a judge and you see the judge once a month and you're held accountable in the moment, and you've done everything that you're supposed to do, paid back your debt to society. As we're currently situated, you leave the program with a conviction. And oftentimes it's that conviction that creates the social harm that we're trying to avoid by diverting from jail. And that is, you know, inability to get the best possible job, inability to live in certain areas, which means your kids are now getting an education from a school district that may not be the best. And we're actively perpetuating this cycle of recidivism rather than trying to break that cycle. And we have the ability to do that if we just spend more time and thought and get the interested parties motivated to help our citizens rather than actively hurting them. That's the most pressing thing that I see in our criminal justice system.
Yeah, thank you so much for sharing that. And then last, before we go, I'd like to just extend the same question to Matt or Lisa, if you have any closing comments, and then we'll wrap up for the evening. Thank you again so much.
Just sort of very generally, and this applies not only to the sort of criminal justice system, but the courts, the court system in general, and it's just an unequal access to resources, services, attorneys, essentially system-wide, civil, criminal, family, and you have people that are very they're on unequal footing, trying to fight some very difficult and very important battles. You have those that are utilizing the public defender's office, or versus, hiring private counsel. In the family division, you have people that can't afford attorneys, and there's no provision for attorneys at all within the family court division. So you could be up against a pretty heavy hitter in the family division and not be represented whatsoever. Any sort of increase in kind of balancing the scales when it comes to two sides not confronting, but addressing the court, would go a long way to not only creating some equal opportunity and some equal access, but also making everybody feel that the criminal justice system or any of the courts are sort of treating them equitably. So.
Thank you so much for your comments as well. I think that was an important addition. Thank you so much to everybody who was here, especially to those of you who stayed a little extra to hear these comments, which I said, again, I think are really important. I hope everybody will be here tomorrow night to see what the other candidates have to say. Thank you so much and have a great rest of your evening.
Thank you, Dee.
Bye, thank you.
Bye, everyone. Take care.
Thank you, everyone. It's very good. Thank you.
You're welcome, Charlie. Thank you.